Hi, it's Washington State Republican Party Chairman Jim Walsh here for our regular Chairman's Update. As I've been saying for the last few months, and you're probably getting tired of hearing me say, this is a very busy year in politics in Washington State. There is a lot going on. We've talked about some of the initiatives, some of the lawsuits, tax issues, congressional races. I want to talk for a minute about something we've touched on before but deserves some particular attention. That is the 5 state Supreme Court judge races that will be on your November ballot this year in the midterm election this November 2026. It's an unusual number of state Supreme Court judge races for a single ballot to have. It's 5 open seats of the 9 total that are on the state Supreme Court, so it's a majority of the spots in the state Supreme Court are up for election this year. Normally, there are 3 spots up for election every 2 years. What happened this year to add the 2 more is there were a couple of unexpected retirements, resignations from the state Supreme Court. So there are the normal 3 that come up every 2 years, and then 2 additional because of those early retirements. What happens when there's an early retirement from the state Supreme Court, or really any court in the state of Washington, is the governor can appoint a temporary judge who then can run as the unelected incumbent at the next general election. So we have the 3 regularly scheduled open seats plus the 2 temporary appointees who have to stand for special election this November. Normally, judge races in Washington, we do, of course, elect our judges in the state, have an undervote. And we've talked about that some before. People will vote for legislators, Congress, members of Congress, or governor, or state attorney general, all these things, but they'll be hesitant about voting for judges because people tell us they're uncertain about who the judges are, who the candidates are, what their different values are, who's progressive, who's conservative, things like this. Judge races are nonpartisan. The candidates do not declare Republican, Democrat, or any other party. And they are bound by rules, not state law, but by rules of the legal profession from speaking in detail about what how they would rule, what they would do on the bench if elected to one of these judge positions. As a result, people have less information about judge candidates than they do about other candidates. And for that reason, they tend to undervote. That is, they'll vote on the other races on their ballot but leave the judge race blank. We believe strongly at WashGOP that this year is an opportunity to really add some common sense and some balance to the state Supreme Court by putting more conservative, more people vote, that they know who to vote for. Now, already, WashGOP, the state party, has recommended, we don't endorse, but we recommend judge candidates because they're nonpartisan races. 2 of the judges, David Larson and David Stevens, and we are in the process in the state party of going through our candidate review, candidate vetting process, and we'll call a special meeting of the state committee to consider making more recommendations, perhaps recommendations in all 5 of the races. So we've got 2 that we already did, there are 3 more we could do. As soon as that process is completed, and that will be this month, in the month of June, we'll get that information out so you can see it. In any event, these judge races are important. We'll link to a media piece I did recently, an interview with the McClatchy newspaper group. They're the Olympian in Olympia, the Tacoma News Tribune, the Tri-City Herald in Tri-Cities, and a couple of other newspapers. And the McClatchy article was picked up by some other online media outlets. It's a good, thorough discussion of these state Supreme Court judge races, and I got to participate in it. The interview that the journalist did with me is a substantial part of the article and review. So I'll encourage you to read that mainstream media article. Pretty good treatment of kind of the state of play on these state Supreme Court judge races this year. It's going to be a big part of the campaign season as we get toward November. Now the state of play with the courts in our state of Washington also touches on the next point I want to raise, which is the death of a young boy in Aberdeen, the city where I live in Washington. Young boy, 4 years old, by the name of Aidan Bevins. Aidan was found dead, buried in a shallow grave in a distant family member's property. It's a horrible story, one that is too familiar in Washington today, where Aidan's parents were troubled, drug trouble, legal trouble, had been in and out of jail at various times, and Aidan had been with a foster family who loved him and took care of him, but was returned to his troubled parent because of the state's well-meaning but disastrous in implementation Keeping Families Together Act. This is a state law that was originally intended to encourage distant family members, grandparents, uncles, aunts, cousins, to take custody of a child whose parents were troubled, instead of putting that child directly into foster care. That was the intent of the bill. It was passed into law, and in practice it has had the opposite effect. The courts have interpreted this Keeping Families Together Act to mean that a child should stay with troubled parents unless there is, and this is the key term in the law, imminent harm, a threat of imminent harm to the child. The definition in the law of imminent harm is so narrow that little children, toddlers, young children, are being kept in homes that social workers for CPS, Child Protective Services, know are troubled, know are dangerous to the child. But the legal standard of this imminent harm is so strict and so high that the courts have said the child should be kept with the troubled parents. You've probably heard these stories where the Department of Children, Youth and Families, the bureaucracy that oversees CPS, has told drug-addicted parents, well, keep your fentanyl in a lockbox, and if you do that, you can keep your child. That's not what the law was intended to do. And we've seen a number of cases. Oakley Carlson was one well-known case, a little girl who went missing and is now declared dead. And now we have Aidan Bevins, a little boy who was found dead, buried in a shallow grave. Children are dying because state law is poorly written. We need to fix this state law. I proposed a bill several years ago called the Oakley Carlson Act that would have made major changes to DCYF and the relevant law. We couldn't get a hearing on that bill. We couldn't get it through the legislature. More recently, some of my colleagues, Travis Couture and Josh Penner in the legislature, have put forward more narrowly focused bills that really just drill on that imminent harm language and fix that so that social workers could get those little kids out of the troubled home. Those haven't gotten through either. Governor Ferguson and Senator Peterson and Speaker Jenkins have refused to allow those good reforms to get through the legislature in Olympia. That's really a tragedy, and we need to do something to change this law so that little children like Oakley Carlson and Aidan Bevins, and there are many others, get out of harm's way and can get into foster care where people will take care of them, better care of them. This is a major problem, and it is indicative of the way that the current governor and legislative progressives like Senator Peterson and Speaker Jenkins refuse even to acknowledge this problem. This is one of the reasons I believe we need a more robust public policy debate around the issues that Washington is facing, the broken law that needs to be fixed in our state. And there's been a lot of talk lately, well, the governor won't debate you unless you file to run against him. The senator won't debate these issues because you're a House member, not a Senate member. It shouldn't matter. This isn't about a position. This is about the policy. It's about the ideas of what our law should say and do. This kind of debate, I've called it an old-fashioned Lincoln-Douglas style debate, isn't about winning a particular office. It's about educating the people of Washington about their laws and their policies and their budgets and how their government works for them or doesn't. We need to have a more robust debate, and I will continue to challenge colleagues across the aisle in Olympia and elected leadership of a more progressive slant in this state to converse, yes, debate these issues in public forums so that people can hear how this Keeping Families Together Act is hurting, literally killing little children. How the raid on public employees' pensions begins a process that has led other states to insolvency. We have to stop that. How the efforts to decertify elected sheriffs are unconstitutional, and grossly so, as even our progressive courts have ruled. And how our tax policies and just profligate spending in Olympia are making it so expensive to live in Washington State that people are leaving. Companies are leaving. We need to have a debate about this, a public discussion. And that's when I believe we, as common sense conservatives and Republicans in this state, will win. That's it for this week. We are busy at work here on your behalf to fix what's broken in Washington. I'll talk to you again next week. Until then, be well and stay strong.